Today's case study is to look at a case in which a woman with a series of underlying health conditions went to a facility, was at risk for development of bed sores, and the facility did not take appropriate steps to make sure that those did not develop. So she went into the facility, she had a series of conditions which would have led the facility to believe that she could have developed bed sores, and because of that, the rules require and the standard of care requires that certain preventions be put in place. These include rotating certain types of mattresses, barrier creams, etc. The records did not indicate that those were put in place, and because of that, she went on to develop a very severe pressure ulcer or bed sore, which required a significant period of treatment, upwards of a year of severe pain and medical treatment surgeries to repair it. Now, in this case, the family came to us after this situation had resolved and said, what can we do? So we researched it, we hired an expert to give us an assessment from an outside perspective, and ultimately it was determined that yes, the facility had probably made a mistake, probably didn't have appropriate measures in place. We will take the case. Now, in some cases, we send a demand letter and try to negotiate a case prior to litigation. We didn't feel that was appropriate in this case, so we filed a lawsuit against the facility. During the course of that lawsuit, our client had to give a deposition. We took depositions of representatives of the facility, and we obtained significant medical records, policies, procedures relating to what they were supposed to do versus what they actually did. Through the course of that discovery, we were able to determine that they had not in fact complied with their internal policies with respect to record keeping, rotations, medical barrier cream application, etc. And so because of that, we put ourselves in a better position, our client in a better position to ultimately be successful. Now, in this case, the facility filed a motion at the end of the discovery phase of the case to have the case dismissed. We brought in experts and fought that off, and the court ultimately denied that motion, which allowed our client the ability to have a trial. The trial was scheduled for very shortly after the motion was decided, and because of the pressure of a potential trial, the threat of a potential trial, the insurance carrier for the facility ultimately came to the table. We negotiated, they negotiated in good faith, and ultimately we were able to settle the case about a week and a half before the trial was scheduled to start. Now, in these cases, we feel very strongly that the prospect of trial is a legitimate bargaining chip. It is a legitimate piece of leverage when you represent a plaintiff in this situation. Juries are unpredictable. No one knows how a trial is going to ultimately play out, but the possibility of having a trial is helpful and can be used as a leverage point in negotiations. We were prepared to have a trial if it became necessary, if the insurance company was not ultimately reasonable. We had our experts lined up, we had the case ready to go, and because of that, we feel that the case ultimately resolved favorably for our client. If any of this sounds like a situation that you're going through or you have questions about it, feel free to reach out to us.